Hey, good afternoon, everyone. Thank you so much for joining. It's 2 o'clock. We are in effectively managing the Freedom of Information Act process. I am Niquelle Allen. This is part of our the Office of Open Government's FY23 DC FOIA training series. I am the Director of Open Government for the District of Columbia Board of Ethics and Accountability. I am an attorney. I've been with the district government for about 21 years. I've been practicing law for 24 years. I've been a FOIA officer before. I'm not one now. We have a FOIA officer for Bega who is on the line, Sharita Berry. Um, but I've been a FOIA officer for a long time, so I'm speaking from experience. I've done some things right and done some things wrong during my time in the district. Some of you may remember me when I was with the Office of the Chief Technology Officer. I was coordinated the email search system. So I got to work with a lot of you when I was with Octo. Also, since I've been Director of Open Government 5 years now, time flies. So thank you again for joining this day after a holiday. I hope you all enjoyed your holiday. We should be going for about an hour. Um, and let's get started. I think folks are joining. So the first part of the training will be an introduction. So if folks are joining late, they'll they can look at the recording. So this meeting is being recorded. We will provide you with a link to the recording after this webinar, and also we will provide you with the slides as well. So a little bit about our office. For those of you who don't know, we are part of the Board of Ethics and Government Accountability, the Office of Open Government, and BEGA advises DC government on the Freedom of Information Act. Our board issues an annual best practices report. It recommends changes to the Freedom of Information Act. That report goes to the mayor. It also goes to the DC Council and the Attorney General. Our office, which is affectionately known as OOG, we issue advisory opinions on the implementation of FOIA. We also serve as an advocate to ensure FOIA is administered fair and executed properly. We're also responsible for training, which is why we're here today, on the requirements of FOIA, which also includes those advisory opinions that I mentioned earlier. That's part of our training component as well as our advisory component. We also assist members of the public with filing FOIA requests to public agencies. So if you ever have a person who comes to your agency who is having problems with filing a request, you can always send them to us and we can help them with the format as well as filing properly. This training today is part of a series that we're given to train FOIA officers. You all have a training requirement, as you know. Last week, Chief Counsel Barton presented nuts and bolts of FOIA. This is a similar course to what he taught. The first course was pretty much a basic overview of FOIA. The course today is taking you through the life cycle of a FOIA request from the FOIA officer's perspective. Next week will be commonly used FOIA exemptions. July 18th, we'll be going over categories of FOIA requesters, fees, and acknowledgement and denial letters. Next, we'll be talking about preparing for a FOIA civil case. I'm sorry, I skipped one. July 11th will be the FOIA litigation updates. Then we'll be doing the categories of FOIA requesters' fees. And then after that, FOIA officer reporting duties and searching for electronic records. And then the last one will be preparing a FOIA, a civil case and FOIA defensive litigation. So we hope that through our series, you will get a full breadth of understanding about your responsibilities as a FOIA officer. And I'd also like to mention at this time, you can use this for legal credit. Please contact Giovanna White with the Mayor's Office of Legal Counsel. Also, if you're joining by phone, please send us an email at opengovoffice@dc.gov to make sure that you get credit if you need that, or contact Giovanna White to make sure that you get the proper credit for attending the course. Now, the presentation contents for today, again, like I said, we'll be going over the life cycle of a FOIA request. So we're going to start with the introduction to FOIA. It's kind of going over what we went over last week. Then we're going to go over the actual responding to a FOIA request. We're going to briefly talk about the conducting searches for records. We're going to talk about reducing those records. And then lastly, we'll go over decision letters. And that's your life cycle of a FOIA request. So what is the DC Freedom of Information Act? As you know, FOIA is a DC law that gives the public the right to access information from the DC government. And let me stop here and say, if you have a question, please put it in the chat. I can't see it, but one of my colleagues from the Office of Open Government will answer that. Also, if you have a question, feel free to come off mute and ask me a question. That's perfectly fine. And we'll have a question and answer period at the end. So going back to the slide, under DC FOIA, DC government must release information that's requested from the FOIA request unless that information is protected from disclosure under DC FOIA law. FOIA also requires DC agencies to proactively request certain information without a FOIA request. That information should be available upon request, and it should also be online under the agency's FOIA tab on this website or someplace on the website. We have also introduced opendata.dc.gov, which has data sets or the data that DC collects, and some pertinent FOIA information may also be there. So while we're back in the office, some of us are still remote, but as we remember, there are physical files or information that might be available without a FOIA request, and someone could come up to the office and request that physical file, and that file should have been there, but now mostly this information is requested electronically. So let's talk generally about DC's public record laws. Now we have a public policy that entitles all persons to full and complete information regarding the affairs of government and the official acts of those who represent them. Now that's our public records. Now, DC FOIA was enacted in 1973, and it was designed to pierce the veil of administrative secrecy and to open agency actions to the light of public scrutiny. So that's why we have these public records laws in DC FOIA. FOIA gives any person the right to request records in any form that are prepared, owned, used in the possession of, and retained by a public body. When we say public body, you see that term, it usually means DC agency. When a FOIA requests are submitted, agencies are required to make a reasonable search for records. And that, as you see, is where you as a FOIA officer will come in. On an annual basis, DC government agencies are required to report FOIA disclosure activities for the previous fiscal year to the Secretary of the District of Columbia and the Council of the District of Columbia. So again, this whole body of DC public records laws and activities are meant to make us transparent. And as FOIA officers, we are kind of the frontline people who make that happen. That's our role as FOIA officers, is to do this action to make DC government open and transparent. Now, the FOIA management process is a who's who. So in addition to FOIA's officers, there's a whole group of folks, which includes us, the Office of Open Government, who handles FOIA. Now, we do not have a central body within DC government that handles FOIA requests. So instead of that, each agency is responsible for processing its own records, and the primary point of contact is you, the FOIA officer. Now, the agency director, I am an agency director, is also a point of contact for FOIA. Now, the DC Mayor's Office of Legal Counsel handles FOIA appeals, the administrative appeals. The Attorney General handles FOIA litigation through the Civil Litigation Division, and also provides legal advice through its legal counsel division. You'll mostly see the legal counsel division providing advice to advisory neighborhood commissioners, but they can also provide legal advice to agencies. And they provide us with legal advice as well, us being Vega. I've asked myself. The Mayor of District of Columbia also created an Open Government Advisory Group, or OGAG. They advise the mayor, I'm a part of OGAG, and other government and other government entities on transparency issues. They include government subject matter experts on FOIA and other transparency matters. OCTO is a part of this group, and members of the public with expertise on open government transparency issues. So again, these are folks who all weigh in on FOIA. Now, going back to why we're here today. So what's the agency's FOIA responsibility? Now, the first of all, the agency head must designate an individual as a FOIA officer. So I'm an agency head. I designated Sheree Berry as our FOIA officer for the Board of Ethics and Government Accountability. The agency must post on its website the FOIA officer's name, title, address, telephone number, and email address. Now that's important so that when an individual wants to file a FOIA request, it must be easy for them to find out who does this go to. Now they can always send it to the director. It's a proper request for it to go to the director. The director should send it to the FOIA officer. But that agency website should identify the person who is the FOIA officer who's going to receive that FOIA request. So if you're sitting here today, you should, of course, go back to your website and check and make sure that your name is on your agency's website. Now, I've noticed that some have a general FOIA email and it goes to that person. I think that's acceptable as long as you make sure that you get it, that it goes to you as the FOIA officer. Now, what's your responsibility? What's the FOIA officer's responsibility? Agency FOIA officers are responsible for tracking, managing, and responding to FOIA requests for records in their organization's possession and control, and administering their agency's FOIA programs. The agency FOIA officer must conduct or coordinate reasonable searches for records and respond timely to FOIA requests. So I know we have different sizes of FOIA programs. So you may have a very large agency, you may have numerous people who assist with FOIA, or you may be a army of one and you're the only person responsible for FOIA. So again, you might need assistance. We are here to help you set up, I guess, a reasonable FOIA program. If it's only one person, if you're a larger agency, I'm sure that you have multiple people within the agency, records officers and such, who are able to go through this process with you. But again, the agency's FOIA officer, it's ultimately your responsibility to conduct that search, manage that search, and ultimately bring that record out or decide that the agency is not going to produce the record or they're going to deny the FOIA request. Now, the next topic is FOIA requesters and the actual FOIA request. So who may request records? Any person has a right to inspect at his, her, or their discretion to copy any public record of a public body except as expressly provided by the FOIA exceptions. Now we say any person because it can be any person anywhere. Some jurisdictions limit who may request records to someone has to reside in the jurisdiction. We do not do that in the district. We're open. It literally can be someone from another country who can ask for our records. There's no ID requirement. It can be literally anyone. So How can that request be submitted? A request for agency record might be made orally or in writing, but it has to be directed to a particular agency. Now, you can ask a requester to make the request in writing, and it can be mailed, faxed, or emailed. So if someone calls you and tells you that they want a certain record, you can certainly make the request to them to send you an email, to send you a letter, to reduce it to writing. The applicable regulations are here. There's 1 DCMR section 400 et al. Contains the rules and procedures that must be followed by all agencies, offices, and departments of DC and all persons requesting records pursuant to FOIA. And you have our the website here is www.dcregs.dc.gov. Now, the FOIA request that you receive must be specific. A request must reasonably describe the desired record. If possible, specific information regarding names, places, events, subjects, dates, files, titles, file designations, or other identifying information shall be supplied. I always say it's just like if someone lost their keys, they would need to describe to you what those keys look like so you could find them. They would need to describe the number of keys. They would need to describe if there's any type of decorative element on the keys, if there's a key fob, what does it look like? Again, the FOIA request needs to be designed so you can actually find what they've asked you to look for. So the law is on your side with that specificity requirement. So what might they ask for? They can ask you for anything. It doesn't necessarily mean that you need to find it, but you might see a request for email messages, text messages, notes, databases, files, communications, camera footage, video footage, photographs. You may see all types of things in a FOIA request. However, you are only required to provide a public record. So what is considered a public record under FOIA? Under FOIA, DC government must provide access to public records, and we do that to maintain a open and transparent government. And the term public record is defined in the DC Code. It includes all books, papers, maps, photographs, cards, tapes, recordings, vote data, including ballot definition material, raw data and ballot images, or other documentary materials, regardless of physical form or characteristics, prepared, owned, used in the possessions of, or retained by a public body. And again, I said public body is usually agency. Public records may include information stored in electronic format. An electronic format now includes text messages and some applications. When I say applications, I mean applications that are on a phone. And we will say it probably now includes social media. It also includes records of some contractors. Now, private contractors might be performing a public function. So that means they're stepping in the shoes of government. They're doing something that the government should be doing. So those records might be included as a public record under DC FOIA. So a FOIA request might capture those records and it might be considered a public record. Now, as I mentioned earlier, there might be records available that are without a FOIA request. Those are listed here: salary information, contracts, budgets, manuals, policies, rules, opinions, orders, and meeting minutes of open proceedings of public bodies. Now let's go on to the meat of the training, which is responding to a FOIA request. When an agency FOIA officer receives a FOIA request, the first thing you should do is acknowledge the request. So you acknowledge the request via email or other initial communication to the FOIA requester. Now, as many of you know, we have an automated system, FOIA Express, that the public may use to make a FOIA request, and that we may use as FOIA officers to process that FOIA request. Now, that system automates this whole process, so the response can come through FOIA Express. But you might decide to go ahead and send an email anyway outside of the FOIA Express. The FOIA officer in this response, you should assign the FOIA request some type of internal tracking number so that you can keep track of it, or use some type of internal system to keep track of all your FOIA requests if your agency is not using FOIA Express. So that's kind of your first step. So you are acknowledging that you received something and you're making some kind of file, or you're tracking it internally. So it can be literally your old school, you're keeping a case file or a manila folder file of the FOIA request, or you're keeping an internal file folder within your computer or within your computer system. But you need to be making sure at the first step is that you are creating some type of tracking mechanism for this request internally and acknowledging the request. So your initial correspondence to the FOIA requester has some type of introduction or acknowledgement, and you might need to clarify this FOIA request. It may not be clear, as I said earlier. You need to make sure that you have a way to find these keys. So you might need to have some clarifying question to make sure you can find them. It might require a discussion of fees depending on what the request looks like. If it's a voluminous request, you might need to let them know it's going to cost a lot of money because it's going to require a lot of government hours. Processing track designation. If one a larger agency, you might have a tracking system that it might be designated as a larger FOIA request, and you have to track it that way. Your contact information, of course, for if they have any questions, complimentary close, your signature, your name, agency, and your title. This is in that initial letter or email. Timing. Now the timing, again, this is your final response. So the law gives you this amount of time for when I call it final, because after this amount of time, the FOIA requester is going to have a right to appeal. So your request will be deemed denied after the expiration of this time. So for records other than body-worn camera recordings, it's 15 business days. For body-worn camera recordings is 25 business days and 5 calendar days in certain instances. So you may extend the time to respond in unusual circumstances. So you can invoke a 10-day extension by written notice to the requester, setting forth the reasons for the extension and the expected date for the determination. So again, that's your final response, after which the requester will have the ability to appeal. So unusual circumstances are defined under DC Code Section 2-532D2 as the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded by a single request, the need for consultation, which shall be conducted with all practical speed with another public body, another agency, having a substantial interest in the determination of the request, or among two or more components of a public body, having a substantial subject matter interest therein, or for body-worn camera recording covered by Section C2 of this section, the inability to procure a vendor that is able to perform the redactions within a 25-day time period provided under this subsection C2 of this section. So again, you can take the extension if you do using the automated system. The feature is included. I think it's just click a button. If outside the system, again, you are sending written correspondence that detail the specific statutory justification for the extension, and you put the date certain of when you will be able to respond. So the consequence of not responding on time is the request is deemed denied. So the requester will be able to appeal the denial to the mayor, which is the mayor's office of legal counsel, which is an administrative appeal, or they'll be able to file a civil action in DC Superior Court. And so next we're going to talk about how to deal with problematic FOIA requests. So the first is overly broad. So this is kind of your kitchen sink request. So the DCMR provides a way for us to deal with that. So it says a request must reasonably describe the desired records where possible, specific information regarding names, places, events, subjects, dates, files, titles, file designations, or other identifying information shall be supplied. So if you receive a request that's overly broad, you just can't figure it out, or it's just asking for too much, and the DCMR says it's not sufficient to permit the location, the identification of the record without unreasonable effort, you need to reach out and contact the requester and ask them to supplement the request with the necessary information. Every reasonable effort shall be made by the agency to assist in the identification and location of the requested records. So again, they need to let you know how to find this record. It's not your responsibility to figure it out. You need to be in communication with them, and they also need to be reciprocal communication with you to try to make sure there's an understanding of what they're trying to have you look for. And the good thing about this is that the time is told. The time period that I talked about, if the clock is stopped until you receive that information. So the regulations provide that a request is deemed received when the designated FOIA officer or agency head receives the request submitted in compliance with the DCMR and with FOIA law. So when you contact the requester for additional information, the request is deemed received when the FOIA officer receives the additional information. So that basically says the clock is stopped, or your time to respond is told until you receive the information back from the requester. So from the practical standpoint, and I think in FOIA Express, there's a button you can push and it tolls and it stops the clock. But you should, in your notes, in your file, if you are outside the system, make sure that you are also making notes that you have requested this additional information and what the dates are and when you have stopped the clock yourself. So we get asked this question. This is not a DCMR response, but this is practical advice. What do you do if they've never respond? And this sometimes happens. The response we've given in the past is to contact the requester at least 3 times before closing out the request for lack of response for clarification. You can assume it's abandoned. We suggest the FOIA officer contact the requester regarding clarifications at least 3 times and give them 2 weeks to respond each time. After the third contact and the 2-week time span, administratively close out the FOIA request after no response and assume the FOIA requester has abandoned the request. Make a note of this in your files and your attempts to contact the requester, because it can go on for perpetuity, and especially again, if it's one of those requests, I think that we see where they have sent a FOIA request to everybody, including the president, and you never hear back from them. You just don't want it sitting there. So this is the advice we've given, especially for those situations where you just want to administratively close your file. Now, what if I receive a request that's overly burdensome? Unfortunately, under DC FOIA, there's no authority to void a request that you receive that's overly burdensome. I know our federal partners do have that option. We do not have that option in the district. Now, we do get voluminous email production requests. These email requests are those where you go through the email search request system, you send the terms that are requested by the email search system and by the FOIA requester, and you receive a large number of emails, and you know it's going to take longer than 15 business days to review those emails. We suggest, and the courts have also suggested, that you contact the requester and work out a production schedule with them. Attempt to produce the first batch within 15 business days, and then work out a schedule with the requester. It's technically still going to be a denial because you're not going to be able to produce it within the 15 business days. But unfortunately, there's no other remedy available. Again, we do not have that overly burdensome remedy within FOIA. We just have to do the best we can and review those voluminous emails. It is a very difficult task. We've all been there. If you haven't had that type of email request, you probably will eventually have that. So I could just say I'm sorry and good luck. Searching for records. I guess the email one is a good segue to our next term, searching for records. So agency employees who maintain records must assist the FOIA officer as appropriate with the identification and search of responsive records. So everyone in the agency who maintains records must assist the FOIA officer. So where do you start? Each agency should have a records officer or a person designated or responsible for agency's records. That employee should assist you with locating the record requested. Examine your agency's organizational chart, as it might provide details as who may possess a particular record. Now, that agency organizational chart should be in the FOIA tab. It should be located in that frequently requested records area. If it is not, I recommend looking on the council's website, usually in the oversight questions. That's another place you could find your agency's organizational chart if it happens to not be where it's supposed to be. I guess that's just a practice tip. If the request for emails or electronic records comes in, the chief technology officer is the one who usually maintains those records, and you may have to request that through your general counsel if you're not the general counsel, or through your office of general counsel. Also, examine your agency record retention schedule to make sure that the record that's being requested has not been archived. I'll make a note to say that if a certain record is of a particular age, it might be in archives. If it is in archives, it is archives' responsibility to respond to the request, and you can forward the request to DC Archives. So what am I required to do as a FOIA officer? You're required to conduct an adequate search for records responsive to the FOIA request. So in assessing whether the district agency conducted an adequate search, the courts look not to the fruit of the search, what you actually found, but to the appropriateness of the methods that you use to carry out the search. So the issue to be resolved is not whether there might exist any documents possibly responsive to the request, but whether the search for those documents was adequate. So that's the standard you're supposed to follow. So how do you conduct an adequate search? An agency search conducted in response to a FOIA request need not be perfect, only adequate. And adequacy is measured by the reasonableness of the effort in light of the specific request. The search must be reasonably calculated to uncover all relevant documents. So reasonable, adequate, it's kind of, I know it when I see it. So you just need to make some effort. And we suggest creating an affidavit or declaration. So an affidavit is a written document that's notarized. A declaration is just a written document that's signed. So As a matter of business practice, we recommend, you don't have to do this, but writing down kind of what you did, describing how you searched a record, especially if you're an agency that might be um, involved in FOIA litigation, it might be a good idea just to write down what you did, how you did it, um, to search for the records. So when a requester challenges the adequacy of an agency search or in litigation when the district seeks summary judgment, the agency must establish beyond a material doubt that it expended reasonable efforts to uncover all relevant documents by setting forth sufficient information in its affidavits for a court to determine if the search was adequate. So, for example, you can write down who you contacted. Um, Again, going back to that um, chart of who does what in the agency, why you contacted them, what files you looked through, why you thought someone may have had a document, reaching out to Octo, what emails you sent to whom, that sort of information is providing evidence for a search that is adequate. So again, provide context for the request. Describe the structure of the agency's file or record-keeping system, electronic or paper, as applicable to the request. Does your agency have a retention policy? Was a search conducted even if the retention policy called for the disposal of the record? An agency must describe at least generally the structure of the agency's file system, which made a further search difficult. So again, you might abandon a search at a certain point. You may come to a dead end. You might know that, oh, well, we just went through the process of what we're doing now, big, and we're moving. So we're going through a process. We're going through all our records and we're archiving things. So you might know that, okay, we sent a bunch of documents to archive. So it makes sense that we don't need to search for this record because we know it's in archives. So that our file system, it made sense for us to send this requester directly to archives. So we're describing, again, the structure of our system that made further search difficult, or we needed to stop because we know this record is not here. So what else may I include? You might explain how your search was reasonably calculated to uncover all relevant documents, detail both how the search was conducted and why it was conducted in that manner. If only one system is searched, make it clear that this system was the only possible place that responsive records were likely to be located. Email searches. Again, how do I conduct an adequate search? The courts have said we do not know and cannot simply assume in this age of computerized connectivity that it would be unreasonable for the agency's FOIA officers to search all the agency's email accounts, regardless of how many accounts that might be. So the courts have really not helped us out as the district when it comes to email searches. As many of you know, we keep all emails for all time. So they look at us like you have it, so you can find it. So again, we really need to have a justification for why we only search a certain amount of emails, a certain amount of email boxes. So just make sure you say something like, we know this person would only have this information because they worked here at this time, that sort of thing. So just make sure you have a justification, or it could just be simply, this person asked for this email box to be searched only. So, with respect to emails, again, if you are one of those agencies that might be involved in litigation, you might want to reach out to Octo and consider Octo one of their employees submit a declaration for you regarding how it searched for responsive records. So it might be, again, unreasonable for Octo to conduct searches of all of its email accounts and have Octo explain why. Again, many email account exists, and Octo's capacity in terms of searching all email accounts is limited, and I'm sure they will tell you that. We will have them at one of our trainings later explain their system, to you, the limitations of it. Again, although it's very large, everyone asks for the same thing. So there are timing issues, there are priority issues, and things of that nature. So that is something to keep in mind and to make sure that you're able to also understand. Fees. Um, Make sure that each person assisting you with your FOIA request keeps a log and other documentation of the time they spent searching for records. Because again, as we know, these fees can add up as the time searching for records adds up. That charge needs to be accounted for in our reporting, and it might need to be charged to the requester because agencies can charge fees for conducting record searches and for producing records. There is no fee to submit a FOIA request, but you can require a requester to pay fees in advance if they have not paid past FOIA related fees. So unpaid FOIA fees might be a justification for withholding a record. You can grant a public interest waiver of fees. One of our future trainings is going to go into that and how you do that. That's usually journalists, but that is something you can also do. But you need to keep a record of that, so we as a district know how much we are waiving for folks as well. So examples of fees, again, hourly rates based on the grade of the personnel who performs the search. Photocopies, I think it's still 25 cents a page. Document certifications, $1 per document. The direct cost of any service or material. Requesters may have to pay search and review fees, even if the search doesn't locate any responsive records or if the records are withheld as exempt. Producing the records is next. FOIA exemptions. We went over that a bit in our last training, nuts and bolts of FOIA. I'll go over it again. We have several categories of exemptions, and these are patterned after federal law, but some are unique to the district. And again, these exemptions allow you to withhold a record in full or to redact. In our training next week, we'll be going over how to do that, but I'm just today just going to recite these exemptions and go into them a little bit. So our exemption 1 is trade secrets. Trade secrets and commercial or financial information obtained from outside the government to the extent that disclosure will result in substantial harm to the competitive position of a person from whom the information was obtained. Exemption 2, this one is used a lot, personal privacy. And this is the personal information of a personal nature where the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. When you're using this one, you have to perform a balancing test. And the balancing test under this exemption is the individual's privacy interest in the material at issue must be balanced against the public interest in disclosing it, and the public interest must serve the core purpose of shedding light on the agency's performance of its statutory duties. So 2 examples here. The privacy interest of students and teachers under investigation for the consumption of alcohol substantially outweighs the public's interest in their identifying information. Another example, you may disclose the names, professional qualifications, work experience of successful job applicants, but refuse to disclose other private information such as home, telephone numbers, addresses, social security numbers, marital status, and personal references, or any information regarding unsuccessful job applicants. Exemption 2A, body-worn cameras. Body-worn camera recorded by the MPD inside a personal residence or related to an incident involving domestic violence, stalking, or sexual assault as defined by the DC Code are exempted. Law enforcement exemptions, investigatory records compiled for law enforcement purposes, including records of DC Council investigations and investigations conducted by the Office of Police Complaints, records that disclose investigative techniques and procedures not generally known outside the government, or those that would endanger the life and physical safety of law enforcement personnel. That's exemption 3. Exemption 4, interagency or intra-agency memorandums or letters that would not be available by law to a party or other agency in litigation with the agency. Exemptions 5 and 6, future examination test questions. That makes sense because you don't want to get the answers. Exemption 6, other statutes, cannot be a regulation, information specifically exemption for disclosure by statute other than FOIA, provided that such statute requires that the matters be withheld from the public in such a manner as to leave no discretion on the issue, or establishes particular criteria for withholding, or refers to particular types of matters to be withheld. Exemption 7 and 8. Exemption 7, national security matters under federal law. 8, antitrust. 9, arson. Exemption 10, emergency response plans. Exemption 11, Social Security and federal employer ID numbers. Exemption 12 is whistleblower, unless the name of the employee is already known. Exemptions 13 through 15. 13 is Homeland Security records. 14, sealed criminal records. 15, critical infrastructure. This applies only to entities regulated by the Public Service Commission. Teacher evaluations is 16. And then our legal exemptions, attorney work product, applies to documents prepared for or by an attorney in anticipation of litigation, no matter the stage of litigation. Attorney-client privilege applies to confidential communications between the attorney and client when the agency is the client and the privilege is necessary to obtain legal advice. Deliberative process privilege, the method through which an agency creates policies, opinions, rules, and regulations. To qualify for this exemption, a record must be pre-decisional and deliberative. Pre-decisional documents are those generated before the adoption of an agency policy. A document is deliberative if it is part of an agency give and take process by which the decision itself is made. The deliberative process does not generally apply to communications that include third parties. It applies only to interagency and intra-agency documents. Communications that include third parties may only be withheld under deliberative process privilege under the consultant corollary if the third party has no independent interest. Their interest is aligned with the government. In the typical case in which a court applies the consultant corollary, the consultant does not represent an interest of its own or the interest of another client when it advises the agency that hires it. The consultant's only obligations are to the truth and its sense of what good judgment calls for, and in those respects, the consultant functions just as an employee would be expected to do. Now, we rarely use this in the district. The GLOMAR response, acknowledging the existence of records would itself divulge protected information. An agency can neither confirm nor deny the existence of a responsive record. The search may not be required if all responsive records are entirely protected. Use caution. Requests can also include responsive non-exempt records. So this would usually come into play if we're dealing with the federal government. So you would, if you deal with the feds, and you would understand the GLOMAR response, but I just want you to make you aware of it, that it does exist, which you've all heard of it before. And we're moving now to actually producing the record. This is the last part of our presentation. A FOIA response does not have to provide answers to a requester's questions disguised as a FOIA request. The agency's only obligations in meeting a FOIA request is to provide access to its records. So you might get a FOIA request that is a list of questions. You would again ask for clarification in that instance. But again, you are just trying to provide the records. That's all you're required to do. And FOIA does not create an obligation for you to create a record that does not already exist. Um, you are just trying to find something that's there. So if it's not there, you have no obligation to produce it or create it. Decision letters. So an agency decision letter should contain the following: whether the record was released in full, partially released, redacted, or withheld in full. So when I went through all those exemptions, that may cause you to redact or withhold a record. So in that instance, if you are redacting or withholding, you would need, which we'll talk about next week, you're going to need to list the reason, the statutory justification um, for withholding or redacting, and that would be in your decision letter. The name and the contact person who made the decision concerning the release of the records, that's you, the FOIA officer. And again, the reference to the DC code provision, that was the basis of the decision. That's usually the exemptions if you're partially releasing or withholding in full, and a statement advising the requester of their appeal rights. And that is that they can appeal to the mayor's office of legal counsel, and they can file an action in DC Superior Court. Now, in your decision letters, do not use the language if it's construed as a not denial. You are denying. It's not if it's construed. It's confusing. Make sure your boilerplate is accurate if you're using boilerplate language. Do not withhold multiple records using multiple exemptions with an omnibus sentence. Example, agency is withholding all responsive records pursuant to exemptions 1, 2, and 3. Just deal with everything separately. The DCMR requires that you identify which exemptions apply with records. And I will advise to keep it brief. I've made this mistake in the past to just being, as a good lawyer, explaining myself. Keep it as brief as possible because you don't want to get a response, a long response back. Just keep it short and sweet with the legal justification just being the statute, and move on. So the FOIA process in a nutshell that we've gone over today. You receive your FOIA request, step one. Step two, you're going to process it. You're going to log internally, create a case file, which estimates your fees, send an acknowledgement. You then will go internally, retrieve the records, search for responsive records, request them from who you need them from. Next, you're going to process those records, make redactions, apply exemptions, calculate any fees. And your last step is approve the release of records or deny the request. And that's going to include the drafting response letter and releasing the record after you receive those fees if you did not waive them. So that's it. This is our office. We are the Office of Open Government. This is our number. Please reach out to us if you have any questions. Again, I'm Niquelle Allen, the Director of Open Government. We have a full staff listed here. We are still in the office some days. We're located in the Berry Building. If you're around, stop. We're kind of going through construction, but we're there some days. Also on the 8th floor. So now we're entering the questions and answers. So if you have any,
Niquelle,
please log on. Yes.
Niquelle, we have a question in the chat from Helen who asks whether the exemptions have to be in the decision letter. Apparently FOIA Express allows them to be appended to the redacted material. And as such, is that enough, or is it a fact that the exemptions have to be in the decision letter?
No, it's sufficient for them to be appended.
Right.
Any other questions?
There's nothing else in the chat.
All right. Well, if there's nothing else, just want to again thank you all for listening and for serving as FOIA officers. We have our next training with Anthony Skirbo, who you heard his voice, next week. And we will have for you multiple trainings as we mentioned. And I think, let me see. I think we had something in the chat. Let's see. Jamari, did I say your name right? I would, Mr. Johnson, Mr. or Miss Johnson. I would love to change the FOIA statute, and I'm in agreement with you. I would love to change everything about email. I think that one, we should have a retention schedule from email that makes sense, but we should have more time for email. So if you'd like to if you live in DC and you'd like to contact your council member about that, I think that would be great. But our board, as I mentioned, they have put that in their best practices report every year since I've been director. So hopefully we'll keep advocating for that change to give you more time. But yes, we will provide you with the slides. And yes, thank you for putting that in your agency FOIA report. And yes, email us with any questions. We are available to help you out. And thank you for serving as FOIA officers. We appreciate you, and we appreciate your dedication to open government and transparency. So enjoy the rest of your week, and we will see you soon. And this is the end of our presentation today. So you all take care. Bye-bye.